Good evening. I'm still at my office, and so this is a sit and talk. With Ari this evening, we discussed, if you will, the military forces that Trump is circulating throughout America, particularly in Democratic cities, to conduct his march to monarchy. That's the way I saw that, and I hope you had a chance to see that. I have a couple of remarks about Comey. And I'll keep it brief because it's late here. And I have animals to take care of back at our place. So in terms of Comey's prosecution, there's a notion among prosecutors of a two-buy drug case, in which two people have a conversation. One's an undercover agent, and he has money, and the other person is the drug dealer. And so the undercover agent gives the money to the drug dealer, and the drug dealer gives the drugs, and then he's arrested. So it's a two-buy drug case, a very simple case, very thin. So why do I say that? Because I think Comey's case is a lot like that. The accusation is he perjured himself. Actually, he made a false statement before Congress, not perjury, false statement, which is Section 1001 of the Title 18 of the United States Code. And so the story goes like this. He had a document. He claims that it was not confidential, it was not top secret, and that he gave it to a friend to hold, but he told them not to release it. The government wants to believe that the document was classified, confidential, okay? And so it was mishandled when it was given to another person. And when it was given to that other person was told to circulate it. In recent days, that person has said, no, he wasn't told to circulate it. And so he's not a good witness for the case, which is probably why former prosecutors who've been fired from the office for not prosecuting the case said that there's no there. So that's the case. Now, if I were his counsel, would I have said, go ahead, take me to court, try me? No, I wouldn't do that. And the reason is because it's such a frivolous case, I would be inquiring whether or not the prosecution itself was wrong. Now, I have several reasons to say that, and I didn't hear all of them today. One is that the prosecutor in the case has no experience as a prosecutor. The canons of ethics require that you have some competence in the law that you're operating on. The canons of ethics also provide, if you're in a supervisory position, you have to be able to do that. She can't do that. They're going to make a motion saying that also technically she didn't satisfy the rules by which she would be appointed. What would that mean? It means it's a technicality that might make the whole case go away. But my interest is in her role as subservient to Trump rather than independent from Trump. And independence from the presidency and the construction of cases and policy decisions about who to prosecute. After Watergate, they were supposed to be entirely independent. Trump has wanted to change that. Why? Because he wants to get even with everybody. Now, there's a notion of selective and vindictive prosecution. Selective prosecution means I've chosen you, and when I haven't prosecuted other people. This isn't so much that case, but it is the vindictive prosecution portion, which is to say, I have a bullshit case, but I'm still going to prosecute you. I'm going to try to humiliate you. I'm going to try to have you do a perp walk and everything. And who knows, I might convict you, and then I would argue you should go to prison, and you'd have some feeling about what I had when investigated, even though when Trump was investigated, he was righteously investigated. So what else do we have going on here? Let's consider the profiles. Now, I believe he tells the truth. That is, I believe that as of now, that Comey is telling the truth. I believe that. So that makes it a worse case, even though I disagree with him on other things, particularly how he handled Hillary. And I don't know that I'm as critical about how he handled Trump, but he has a little bit of hubris, and he's a little too smart by half, which is unfortunate. He has an excellent lawyer, Fitzgerald, who was the U.S. attorney in Illinois for a number of years. I think it's 12 or 13. Had very tough cases, did very well with those cases, very smart prosecutor. I don't know what his experience is like as a defense attorney, but I do know he's a solid lawyer. There's no question about that. But he's been retired for a number of years, and getting into a wet bathing suit is not easy. But I don't think this is a case that commands a lot of demand of his ability. So now, there are two names in the indictment, in the two-count indictment. One count says you lied about this transaction I described. The other count says you obstructed and impeded a government proceeding. Okay. If it's not confidential and it wasn't released, nor did he ask that it be released to anyone, then I think there's no there. Okay, so there's that. And what the prosecution is going to do is they're probably going to resist, in part because they don't know the case. The two people who showed up today in court were recruited from the Carolinas in the U.S. Attorney's Office there, and I think they are experienced prosecutors. But they know more than the U.S. Attorney. That does happen, but not in my experience. And because the whole model is to have a leader to lead other prosecutors in ethics and fact-finding and advocacy and so forth. So we have all that. So what are the first arguments? Well, I was surprised to hear the defense counsel Fitzgerald say, who is person one and who is person three? Well, person one is Clinton, because the information was about her case. And person three is the person that they claim had the information from Comey and did circulate it, although Comey didn't ask him to do that. I'm a little suspicious as well that they subpoenaed that person, that is, the government did, in recent days. The question I have is that they subpoena him after this indictment, because you cannot, once you've indicted someone, continue to use that grand jury to investigate additional information because you've already issued that indictment. What can we expect? Well, the judge has set it down for January the 5th for trial, if I remember correctly. And the rest of it is discovery. And if there's really only one document and it's not classified, if I were in the case, I'd ask the court to declare it's not a confidential document. Bang, that's done. And did you guys actually talk to the witness, the other witness? Yes, and what were the circumstances? And there is this provision in criminal law in which if you have information that exculpates the defendant in the case, you have to surrender it. So if the person who allegedly received the information from Comey said, I didn't pass it on to anyone by his direction, then that would be what they call Brady material after the Supreme Court case that enacted this provision. And then a court would have to consider what it would do. Now, it looks like it's a he said, she said case, meaning I think there are only two people in the case. So it could go out the door for that reason. It could go out the door because it's vindictive, if not selective prosecution. It could go out the door on the facts itself at the trial. So those are the three bridges that I see. Some people, I heard comment that maybe there are other cases that they're making against Comey. I think that's irresponsible because I've heard nothing. No one knows anything about there being any other cases but this one. And if they had other cases, why were they so desperate to get this one underneath the statute of limitations so that they could have a viable case to chase him around the room? So that's basically my additional stuff, and tomorrow I'll probably be outside talking, and I'll talk to you then. So have a good evening. All the best. Bye-bye.